Good afternoon, everyone, and welcome to the Alternative Dispute Resolution Certification Working Group. I want to remind you all that this meeting is being recorded. Angela, would you please take the roll?
Armstrong. Coulter.
Here. Armstrong here.
Thank you. Coulter.
Here.
Curtis. Dinkin.
Yes.
Dubois. Ellis.
Here.
Dr. Getz. Higuchi.
Here.
Hodgson. Jones.
Here.
Kelly.
Here.
Kopaken.
Here.
Cruz.
Here.
Lowe.
Here.
Judge Lucky.
Here.
Pulaski.
Here.
Judge Kuchan.
Here.
Robertson is absent. Tuckman.
Here.
Welch.
Here.
And Yamshan. Thank you.
Thank you, Angela. And next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendance pool. Angela, would you please provide the instructions?
Yes, for those participating by Zoom, please use the raise hand function at this time if you'd like to make a public comment, and we'll call on you in the order that your hands are raised. For those participating by phone, you can raise your hand by pressing *9. We will give each person 3 minutes, and you'll be alerted when you have 30 seconds remaining. So if you'd like to give a public comment at this time, please use the raise hand function.
Thank you, Angela.
I don't see any raised hands, Chair Bishon.
Okay, thank you very much.
Well, actually, one just popped up.
Okay,
I have James Park. James, one moment. Your mic has been enabled, and I'll start the timer when you begin. And I think you're muted, James, if you want to unmute your mic.
Hello.
hello.
Hi.
Hello.
Hi. So this is my first meeting. I'm an employment lawyer in California, and and have been practicing for over 20 years now. And again, this is my first attending this meeting for the first time. And I had a question, and I don't know if that's something that can be addressed here. Is how were the committee members chosen for this committee?
I'm going to refer that question to staff.
Sure. Mr. Park, I can answer probably in more detail offline if you'd like to shoot me an email. But at the high level, there were several stakeholder groups that were asked to nominate individuals to join the working group. And then those stakeholder groups did so. And then there were about a combination of those as well as individuals who were appointed or asked to join the working group by staff. So this is a staff created committee of the State Bar. It's not a Board of Trustees created committee.
Okay. So once the law was passed, the staff of the State Bar reached out to various organizations and asked for nominations. Is that correct?
That is correct, Mr. Park. Typically, the public comment process is not really a Q&A. It's an opportunity to give public comment. So I'd ask that if you don't mind, if you have questions about the composition of the working group or how it came to be, I would encourage you can please send me an email and I can address those.
Okay, will do. I'll do that. Thank you.
Thank you. Angela, are there any other members of the public who wish to speak?
I don't see any hands at this time.
All right, thank you. Now we'll move on to the approval of the February 19, 2025 open session minutes. Are there any corrections or modifications to the open session minutes? Yes, Mr. Kelly.
There was a motion that we voted on that the legal press found significant enough to report on. I'd like to respectfully propose that that motion be included in the minutes and at least the summary total of the vote, if not who voted for what, be included in the minutes. So I'd like to make that motion.
Chair, if you would like, I can.
Yes, please. Thank you.
Mr. Kelly, are you referring to the straw poll that was done?
Yes, ma'am.
Okay. So to my understanding, that was not a formal motion.
I went back and looked at the video. It was a motion. You ruled it didn't need a second, so it probably falls in some middle category, but I made it as a motion. We did vote on it, and I did go back and look at the video and would be happy to give you the exact wording of it if you like. But that's my motion now, is that that be included in the minutes. And that motion may need a second.
Okay, first of all, I see a hand. I see your hand, Diana.
I second Mr. Kelly's motion. I think it should be included in the minutes, and then the staff can phrase it after reviewing the video as appropriate.
All right. Any discussion regarding that motion? Okay, we'll take Mr. Kelly's motion first. So all in favor, please say aye.
Aye.
Raise your hand so we can see.
Sorry, Judge Pichon, we would need to do a roll call,
I'm sorry,
formal
that's
roll
right.
call on this. Thank you.
Yes, thank you. Angela, would you please call the roll?
Yes. Armstrong,
No.
Coulter,
Yes.
Curtis,
Yes.
Dinkin.
Yes.
Steve Dink,
Yes.
Dubo, Ellis,
Yes.
Dr. Getz. Was that a yes, Dr. Getz?
Yes.
Thank you. Higuchi? Higuchi?
You're on mute.
Yes.
Hodgson? Jones?
Yes.
Kelly?
Yes.
Opakin?
Yes.
Cruz?
Yes.
Lowe?
Yes.
Judge Lucky?
I think I have to abstain. I wasn't present.
Palevsky?
Yes.
Robertson is absent. Tuckman?
Yes.
Welch?
Yes.
Yamshon?
Yes.
And Judge Pichon.
Yes,
So the motion carries with the majority.
thank you. Are there any other corrections or modifications to the minutes? May I have a motion, please?
Move up the minutes as amended.
Is there a second?
Second.
Thank you.
Sorry, I apologize to interrupt for interrupting again. If I may, it may make sense to not move the minutes and wait to see what this looks like prior to adopting them. So essentially they would be tabled until the next meeting for a vote. I just would hate for you to adopt minutes without seeing what this includes and then repeat this process, but I'll defer to you, Chair, as to what you would like to do as far as how to proceed.
Yeah, and Erica, this is Nolan Armstrong. I'd be inclined to change my vote to yes if that's the case. I just wanted to see what the minutes are actually going to be reflecting. So I'd support that.
I withdraw my motion.
I'm sorry, so is that the motion? Oh, I'm sorry, yes, I
Just to
understand.
approve the minutes, yeah.
Thank you. All right, so then we will table the minutes until the next meeting, and then we will vote on them with the amendment that has been made today. All right, so we'll move on to the next item, which is the chair's report. And I do not have anything to report on for this meeting. That moves us to the staff report. And I am informed that staff does not have anything to report at this time. Next, we'll move on to the business of the meeting, and that is item 2.6. And we'll have a brief presentation. First of all, is Danielle Hutchison here, Angela?
She is.
Okay, all right. So we'll have a brief presentation from Danielle Hutchinson, who will present on Australia's National Mediator Accreditation System. And she is one of the few this is one of the few mediator accreditation programs that includes a tier component. Ms. Hutchinson is here, and I'd like to tell you a little bit about her first before her presentation. Danielle Hutchinson is a globally recognized dispute resolution expert and cross-disciplinary innovator specializing in mediation, negotiation, and neuro-inclusive practices. She is a pioneer in the empirically grounded standards and AI-enabled decision tools for dispute resolution's future, working with organizations like the International Mediation Institute, United Nations International Labour Office, and various judicial bodies across Australia and internationally. She holds a patent for an AI augmented system that helps courts identify optimal dispute resolution processes for a given dispute. In 2024, Danielle was engaged by the Chartered Institute of Arbitrators to develop the world's first global competency standards for arbitrators and adjudicators, following her co-authorship of Australia's National Mediator Accreditation System Review. Danielle has held several academic posts and currently teaches at Melbourne Law School and the University of New South Wales. She is also completing doctoral studies in economics at HHL Business School in Leipzig. Ms. Hutchinson.
Hello. Sorry.
Welcome.
Thank you so much for the opportunity to join you all here. I'll probably say this morning because it's 7 o'clock here in the morning. I think you're at a more sensible time sometime in the afternoon over on your side of the world. But I appreciate the opportunity to share a little bit of information about what we've been doing in Australia and also with the Chartered Institute in the UK. I will also flag that my cat Oscar is here this morning, so you may see a tail swish across. It's not your imagination. It's my cat just wandering around here. So I think probably the first thing just to say is that having had a look at the task that has been set before you in terms of not only having a tiered system, but also the fact that it's heavily focused on sort of the ethical obligations rather than the knowledge or skills in terms of the tiered element is something that brings a level of complexity to your situation, and it's a big task that's been asked of you to do it. So hopefully some of the ideas that I share today might be helpful, but I am very aware that the work that we did in Australia was very much focused on the knowledge and skills in terms of the tiered system, even though we did look at the ethics and we analysed it using tiers, but when we ultimately produced it, we produced it as a flat structure for the ethics. So I just wanted to flag that to say that the work that we did is not going to be directly applicable because of the differences there, but the underlying principles I think might be something that can inform the process that you're going through. So I guess the thing is, I don't necessarily want to spend a long time going through a long PowerPoint presentation because I want to make sure that I actually answer the questions that you're curious about, because I could talk about it all day. But I think probably just if we could put in the chat, would be really helpful for me. If people do have specific questions that they would like, if you can pop those in there, that would be great. Also too, I do invite you to stick your hand up and ask questions as we go. For me, it's sort of a little bit more useful if we have it a bit like a conversation. So that's there. But what I'll do at the moment, I can just share my slides in this first instance. Sorry. Just there we go. Sorry, get all the right bits and pieces up. And share. Okay. So just want to check that everybody is hopefully seeing the screen that I'm sharing, which is overview of the National Mediator Accreditation System. Is that the one? Can I get a nod? Yeah, just fantastic. So in the first instance, one of the things that might be useful for you to all know is that there is a website called the NMAS Review Hub, and that link is there, and a link and documents have been provided to you for you to be able to access. Just about most of the things that I talk about and the process, all the products that came out of it, and even some of the elements of the workshops that we ran and the preparatory materials, they are all within that hub. One of the things that was really important to us was that this was a transparent process. So you can all go in, and if anybody's got any questions or things that they want to follow up, you can definitely take your time going through the NMAS Review Hub to have a look around and see that broader process. So there's a number of different elements that we can look at. There's I might give you just a little bit of information about the Australian context in the first instance, and then perhaps I think it would be useful to be guided by you, because we just have a short period of time. And I want to make sure that I give you exactly the bits that you're after. So in terms of accreditation for Australia, like most places, it really did ultimately end up being about making sure that there was this sort of recognised level of quality. And I'll be very clear, in Australia, it is a voluntary system. It's not a mandatory requirement that somebody has mediator accreditation. And it's very much focused on a system of recognised accreditation bodies that are linked into a centralised register. And so it's not that there's a main accrediting body that all mediators or the various different types of dispute resolution practitioners, they don't join that directly, but there are what they call recognised mediator accreditation bodies, which are the ones that accredit the practitioners. But what that means is that it allows for different levels of specialisation. So, for example, we do have one at our Victorian State Bar, and they accredit people that are barristers. And so they're the trial lawyers. So that accreditation will go through them. And then it's the Vic Bar accreditation body that aligns with the Mediator Standards Board. So really, we've been going in terms of this voluntary accreditation process. It started back in 2000, and we've been working towards that for a while. There was this report about concerns about the variability, and these are sort of universal concerns that have come up through, around the world. Any group that's adopted some sort of certification, it's been about this concern about variability, and also this sort of notion of trying to raise the profile and understanding of the role of dispute resolution practitioners, and that trying to build that element of public trust. So this idea that if you have this credential, the public can trust that you know how to do certain things, or that you will behave in certain ways, or that there could be certain sorts of expectations. And they were particularly concerned about that as mediation started to take hold, and it was being involved in particularly high stakes situations, it became apparent that it was like we we don't necessarily want to mandate it, but we do want to be able to provide something where people can elect to join as a flag or a badge of some sort of trustworthiness or credibility, and that, you know, a guarantee of certain types of skills. So it really was a matter of it becoming embedded in the legal community and making sure that it was, we could also, part of it was also that we could get a picture of who was mediating, where they were mediating, and what sort of fields it was covering, and the types of disputes. So it wasn't just about saying, oh, there's a concern about trust for mediators, but it was really about this idea, which you might grapple with as well, is that if mediation is to become a profession, or alternative dispute resolution, whether it's arbitration, mediation, or adjudication, to become a profession, there has to be a recognised body of knowledge. And if we've got no idea what anybody's doing, then it's very hard to suggest that we have a recognised body of knowledge, that there's been, you know, research, ongoing monitoring about growth and change, the evolution of practice, all of those sorts of things. If that's not embedded, it's one of those things where a mediator or dispute resolution practitioner may be professional, but it's not necessarily a profession. So that was sort of part of the impetus as well. So as I said, it was a voluntary process, but it was coordinated through the Mediator Standards Board. And these are sort of the key milestones that we went through. So as you can see, we've been going for up to about 25 years. And like a lot of mediator accreditation processes, initially we did start with what we called was a hypothesized progression, where essentially you would get a group of experts in, they'd sit around a table, they might consult across their different areas or disciplines or specializations, but it would often be a group of experts that would sit together and draft something, possibly put it out for public consultation, but then that would be agreed on, and we'd work, and they'd work from there. So that was developed finally in 2008 by Tanya Sowden. She's at Newcastle University, and that was our first framework. They then did a review of that in 2015. Again, that was an expert-led review and consultation, and that's when the NMAS standard was released. In 2020, between 2020 and 2022, myself and my business partner, we did what we called an independent review. So previously, Tanya Sowden, she was connected and she was involved in the initial setup of the Mediator Standards Board, whereas myself and my business partner, while we were accredited mediators, we weren't necessarily involved with the board. And I think part of the thing that happened there was that in a previous life, I was an academic in the field of education, and I had been involved in teaching and researching assessment and measurement, performance measurement and evaluation. And had been involved in the development of the standards for principals in Australia. And so when we were putting in our tender to the Mediator Standards Board, I talked about the fact that in education, there'd been a long history of being able to use statistical analysis and psychometrics to be able to validate these progressions, because sometimes we can say, all right, we think it goes like this, but do we actually have any data to be able to test that? And so the Mediator Standards Board were brave, and they said, all right, we're prepared to give that a go. And that's how we were able to develop a tiered system, in that what we did was we used the existing framework. We had a very collaborative process. There was over 500 people actively involved, but we had, I think it was 78 people in our reference groups and working groups that helped us co-design a survey and instrument to be able to measure, gather data on practitioners' knowledge and skills, and also in relation to their ethics. I'll flag there's limitations to that because some of that was self-reporting. However, in doing what we did then was we did come back, we did the statistical analysis. We were able to find out that there were 3 distinct levels that we could create in terms of a tiered system, because that had come back as something that people were saying look, if we set the level low, that's okay when you first start, but that absolutely doesn't reflect practice as you grow. Whereas some people who say, all right, well, let's make it more aspirational, what would happen is they'd set the standards there, but you knew that when people passed, there was no way that they were meeting that standard. So what would happen was inadvertently, you'd teach people just to ignore your standards because it didn't really apply. But being able to use the statistical analysis, it meant that we were able to validate in the first instance that yes, these progressions that were consistent with progressions of learning and skill development that had been recognised in education for a long time. We could develop that tiered system, and now we have a baseline, and over the years we can continue to test whether or not that's correct. So the fact that the initial is self-reporting, that's totally fine, because we can do observations and we can do further research with that baseline established. So we submitted those findings, and it's the case with all recommendations that you submit. They'll adopt some and not others, but pleased to say in terms of the knowledge and skills and the recommendations that we made around ethics, they did adopt those. And now they're transitioning to what they're calling the AMDRAS, which is a broader scope of accreditation, because part of what they asked us to do was to evaluate whether or not practices like conciliation and family dispute resolution, whether or not that would fit under the broad umbrella of the accreditation system for how we're trained in Australia uses that sort of the orthodoxy of the facilitative method. And so whether or not those other practices could be described in ways, or that we could create a framework that was able to sufficiently describe the various differences of the practices so that we could put it all under one umbrella, which we were able to do. So that's the history of Australia. And I think we are still in the process of implementing all of this, this next phase. The rest that I have, I think, is really probably what's more important is to find out from you if you've got specific information that you would like. But one of the other things that I would also like to do is just to share with you that having done a little bit of thinking and read about the legislation that was brought in and the recommendations that were made for you, I think that I have possibly some ideas about maybe how you can tackle it, and that you potentially, this whole thing that we did in Australia was massive. It took 2 years, and it may be that there isn't a call for a tiered accreditation system in California that relates to all of the knowledge and skills. However, I do think that based on the idea that it's about potentially linked very closely to the ethics and the kinds of ethical obligations and the way that people would conduct their practice, and the idea that there would be a complaint system, that I think there is the potential to be able to again lean into a cross-disciplinary approach that draws on education. And there is a framework that you could model it on, which is called Krathwohl's affective domain. And that's the one we did use in our ethics. And when I think about Krathwohl, I tend to describe it a bit like a gym membership. And so it's that thing of sometimes we can go, all right, we know we need to exercise, and there'll be some people that'll go, no, I'm never going to do it. I'm just rejecting it outright. So that's sort of that level of going, no, it's not worth it. Then there are some people who will, for some reason, they'll be in a situation where they'll say it's a compulsory requirement of whatever it is that you're doing, that you have to go and do these activity sessions. Maybe you have to go to rehab or something like that, some sort of rehabilitation because you've, I don't know, broken your leg or something. So you're having to go through and do these exercises, but you wouldn't do it if you didn't have to. Then there are other people that go, yep, I know I want to go to the gym, I pay my membership, they know it's a good idea, but they never actually make themselves go. And then you've got a next level of people who pay their membership, they know it's a good thing, but then they organize their life to be able to embed it in there. So that's just part and parcel of what they do. And then sort of you've got this really high tier of people who they're the ones that are out there spruiking, going, go to the gym. This is fantastic. How can I help you get to the gym? I want to teach people about the gym. Maybe I want to become a PT, personal trainer. So there's different level of engagement, different types of obligations, and different types of expectations of people, depending on what their attitude is and their engagement is with this sort of exercise and gym scenario. And that's the framework that we typically apply to things that are attitudinal or values based. And there is they're thinking, reflecting on what's been asked of you. I think that based on the work we did in Australia, that's probably where there's going to be the closest alignment in terms of being able to leverage a framework like that, or draw on what we did in Australia to be able to help you tackle this very big task that you have been given. So that's sort of the main body of information that I wanted to share with you in the first instance. But now I'm open to talking about anything that, or answering any questions, or talking about anything that's really pertinent for you. I can see Daniel. Well, I'll let whoever's chairing, if you wouldn't mind, because choosing and letting, deciding who goes next, because I'm not quite sure of the formalities, if there's any sort of formality about how that needs to be done.
Sure, thank you. And thank you, Ms. Hutchinson, so much for your presentation. I can't see everyone, so if you don't mind taking down your screen. Thank you.
Okay.
So let me go first to our staff, Erica or Alan. Is there anything that you'd like to say following the presentation before I move to the group and their questions? Yes, Mr.
Yes,
Wiener?
Thank you, Judge Bashan. I just had a quick question. I missed the name that you mentioned of sort of the framework for the educational one, where you use sort of the gymnasium and commitment to exercise. What was the framework called?
That's called Krathwohl's. Yeah, Krathwohl, Krathwohl, affective domain, and I am very happy to send you a paper on it, Alan.
Thank you very much.
No worries.
And Erica, do you have anything?
No, but I may put Alan on the spot and to describe how this came up and how we were able to have Ms. Hutchinson here today.
Sure. So when I came on board with the State Bar to help with this project, I reached out to several people who I've worked with in the past. One who many of you or some of you may know, Jim Malamed, and others at mediate.com. And I just asked, they have a sort of, if you will, a paper credentialing system, and I kind of wanted to learn about that. And Jim Malamed was kind enough to inform me that there's a national mediator accreditation initiative taking place here in the United States. And he connected me with that group, and Ms. Hutchinson was a member of that, and has, I think, been sort of a subject matter expert, if you will, contributing to that group's process. And when I started looking at some of the materials, and particularly the materials about tiers, which is something we haven't gotten to yet, I thought it might be helpful for the group to hear from Ms. Hutchinson, and I've certainly found it informative.
Okay, great. I see Mr. Yamshan, your hand is up.
Thank you. Has Australia also developed a credentialing program for arbitrators, or is it strictly for mediators? And if so, do you also have tiers?
Okay, great question. We do have a credentialing, we do have a body for arbitrators. In terms of tiers, I have not been involved with the arbitration body, anything to do with arbitration in Australia. The work that I've done on arbitration is through the Chartered Institute of Arbitrators, which is The headquarters for that is in London, and that definitely has a tiered accreditation process, and I'm currently in the process of helping them with their assessment, their curriculum design, and reviewing and going through a review and looking towards how they might be able to validate their progression. But I haven't been actively involved in the arbitration in Australia.
Thank you.
Ms. Cruz?
Well, Dan stole my first question, which is fantastic. I'm a proud panelist on the ACICA panel, so Australia's largest arbitral institution. And it sounds like you're not familiar with their system, Ms. Hutchinson, or maybe you are.
I'm loosely familiar to the extent that I am joined together with LEADER to form Resolution Institute, and I'm familiar with the people that were involved there and people that are arbitrators, but I have not been involved directly with the field of arbitration in Australia. That's been with the Chartered Institute. So you probably know more about what's happening in arbitration in Australia than I do.
In terms of the second question, when you were developing your tiers for mediation, did you think it was important to have a strong division between like the bottom tier and the top tier? And maybe to just use your gym analogy, like, do you think it'd be a good idea to require 5 hours in the gym for, the bottom tier and then 6, 7, 8? Or did you all talk about that? How much division should be between the tiers?
So what we did was when we designed our questions, we lent into, again, the EdPsych, and we used some frameworks that looked at the complexity of knowledge development for the development of knowledge for mediators, conciliators, family dispute resolution practitioners. And we also looked at the development of the skills. Then when we went through and did the analysis, we essentially were open to the possibility that it would turn out that there wasn't tiers. So we didn't actually have a set agenda to create a certain number of tiers, but the hypothesis was that those tiers would emerge. So, and what we ended up finding was that they were entirely consistent with the educational models that have been developed previously, but that we could describe them with the knowledge and skills specific to dispute resolution. So I think I have two thoughts about that. The first thought is that if you're going to do it and you don't have scope to do the statistical analysis, it makes sense to me that you rely on the models and taxonomies that are already there, and then you would decide based on your context how big or small the gaps that you want. Like, so it might be that you don't go all the way at the top. Maybe you have 2 levels and one's down the bottom and one's in the middle. So it really, I think that's the benefit of this, is that you actually have the flexibility to look at your context and go, what would work for us? And then because you've started doing that, it's got a strong research basis so that you can start to collect evidence and then test whether or not that works, and whether or not the choices that you've hypothesized about in the first instance are correct. So then that brings me to the second thought, is that I'm a data nerd. And so in the end, if I can collect data, I'll let that make the decision. Obviously, you have critical thinking around that, but that would always be, because one of the things that we found in terms of specializations, there was a debate in Australia sort of about, who's got the highest skills and what's the hardest place to resolve disputes in and what's more difficult to. Anyway, when we did the analysis, we were able to identify that the most sophisticated form of subject matter expertise related to the psychosocial, cultural elements of being able to facilitate and guide a mediation or dispute resolution process. So that meant when we were doing our specializations, we could say, look, we've got data to say that if, for example, they were bringing in First Nations mediation, that is going to be recognized statistically as at the highest level of sophistication of practice alongside things like family dispute resolution, which according to, if you spoke to everybody, people would say, oh no, that's the soft type of mediation. That's the one that's not as hard. But statistically, we're able to establish that that's not actually the case. But what can happen is that can go on to be tested over time. And then you don't have to argue. If it turns out that in 15 years, that's no longer the case, then that's in 15 years, that's no longer the case. But you're using data to make those decisions rather than having to have a bunch of people just sit around and go, oh, no. You know, that because everybody thinks theirs is the hardest and theirs is the best and theirs is the most special. So, you know, so I think there's two ways of looking at it.
Thank you for staying up late and sharing your insight with us.
No worries.
Mr. Kelly.
Thank you. Is it Professor Hutchinson?
No, I'm not a professor, but I am a lecturer.
Okay, Ms.
Yeah.
Hutchinson.
Yes.
Thank you for presenting to us. I'd like to ask you to reflect on all of your own experience based on sort of a sieve that we're presented with because of our legislation. Legislation says that our tiers, the higher tiers are to be awarded to people who demonstrate a higher level of commitment to accountability and protection, but that they don't reflect an assessment of quality, and they're to be awarded only on the basis of particular specified standards of conduct. So we've got a very fine sieve that we're sort of pushing this through. And I'd like to ask you, based on all of what you found, which elements do you think would survive going through that fairly narrow sieve?
Well, I do think things like commitment to perhaps, I'm trying to think of the different contexts. I mean, there's an element there in terms of transparency with complaints handling. So having an accessible and transparent while maintaining confidentiality. And I know that can be alarming sometimes for some mediators, but it's, you know, psychologists and people like that have been able to navigate that for a long time. So things like complaints handling, things like the kinds of things that you will do with and not with, you know, with or without documents, things in terms of perhaps the parameters of do's and don'ts. So it would definitely be things like, you know, and the things such as, you know, it being non-determinative, whether or not, and I struggle a little bit here because I don't know exactly. There are different places that do different types of mediation. So in some places, it's entirely normal to be evaluative. In Australia, that's a bit of a no-no. So I'm partly coming through that lens as well. So if you're in Australia, it would be that the mediator or dispute resolution practitioner, obviously not arbitrators, doesn't provide any form of opinion without the express permission of the parties. So that would be something that would need to be informed and agreed to by the parties prior. So essentially it's like you're not switching your process out so that parties join in and agree to one process and then you decide that it just sort of turns into another one where you're giving opinions. So I think that there are a number of ways that or concepts that could definitely go through that in terms of ethics. Whether or not there's an element in terms of voluntariness, self-determination, I don't know where that stands in terms of what's expected with your courts, because that can sometimes be a sticky issue as well. Sometimes there can be issues about referrals, where your work comes through or where you have alignments with other people, whether it's experts and those sorts of things. But often it's about transparency. Conflict of interest is also another thing in terms of declaring those sorts of things. And I think sometimes too about information sharing. So there are certain nuances in Australia depending on the context that you're in, and also depending on whether or not there's the potential for a hybrid process, like a med-arb or an arb-med, med-arb-med, so that how information is handled. So I think those sorts of things in sorts of information handling, confidentiality, conflict of interest, what your associations are in terms of there's nothing underhanded or people not taking inducements. In Australia, you're not allowed to have a success fee. So the sort of garden variety things that tend to be attached to ethics.
Thank you. I don't see any other hands. Are there any questions? All right. Ms. Hutchinson, thank you so much for sharing your time and your expertise with us. It was certainly most informative and we appreciate it. And yes, Alan, Mr. Weiner, I see your hand.
Yes, Judge Bashan, I'm just want to mention that I see Paul DeBoe's hand raised. Apparently it's not on your screen, but I can see it.
Thank you. I can't see it at all. Yes, Mr. DeBoe.
Maybe he's muted.
No, I think he needs to be promoted to a panelist.
I think there's two issues. I see him, I'm assuming that is actually Paul DeBoe because it just has a first name. So let's, staff will connect with him by email, Paul, if that is you, and we'll get you promoted. So hang tight for just one moment.
Okay, so we'll wait a moment.
So also just to flag, I think there was the document that there, my contact details are there. So I'm totally happy if someone's got a question, you can just click me an email and I'll get back to you.
Thank you. That's very generous.
Okay, as far as getting, again, with the assumption that that is Paul, getting him moved into the right area, I think that's going to take a minute or two, Judge Pichon, if you'd like to move forward. Oh.
Okay, because that will, yes, Ms. Curtis.
While we're waiting, I just had a question about the data that you used to establish your tiers. I'm curious about how that was determined. And then maybe a related question about, was it based on quality of the, or I should say based on performance, or was it simply on training in the area of practice and that sort of thing that you determined tiers? And thank you so much for your presentation and being, up so late.
That's totally fine. Thank you for the question. So I'm just thinking that it might be useful for me to share my screen because I do have something on that. Oh, sorry. I just need to have that. Oh, there we go. Good. That's fine. Okay. So in terms of, and yeah, I think that's the right one. So in terms of the, if I go to introducing the data, what we looked at was, as I'd said, this is something that has been used in a range of different contexts in terms of the data methodology. So what we did was we looked at attributes of the mediator. And so here's an example of one of them. And so we were sort of saying, all right, how what are the actual attributes, so the knowledge, skills, and ethics, and what is it that sort of really distinguishes them, and the how that works over time. And this is what we ended up in terms of the professional attributes. And we had questions in terms of knowledge, so things that people would know, and we created a survey to describe different levels of knowledge. So for example, if you were thinking about conflict theory, it might be that somebody could name the main features of a conflict, or define a conflict. Whereas at the top level, it might be that someone was able to, evaluate the features of a conflict. So you're looking at how people, what the level of sophistication with which somebody might grapple with the knowledge. And then we were looking at, in terms of skills, we were looking at what was the difference between when somebody first needed to do something and often needed to follow the rules, as compared to someone that was very experienced, that could draw on that knowledge, knowing that, well, I've done this, these 17 other times, and I know that it probably looks like, according to the rules, I should do this, but I know that in this instance, this is an appropriate time to break the rule or do something that's unorthodox. So that was sort of the models that we used, and we had a series of questions. So it was self-report. It wasn't observed at this point. However, the way that the questions are formed and the way that the standards are formed means that all assessment that is done the data can be gathered, inputted in to validate those measures and those frameworks over time. So we can find out if those models that, in terms of the self-report, were inaccurate. There is capacity within the way the framework is designed to find that out. So if I just go to this, I just want to get to the data part. So this was, here we go. So this is one of the examples for attribute number 1. So we had these questions in there and people had to self-identify. They're long, convoluted, slightly convoluted questions. And that was part of one of the challenges in setting it up the first time, is that sometimes what you'll do is you'll end up asking more questions than you need to, and in time you can synthesize it out. So it's a bit like if you're asking a child to demonstrate that they can add numbers to 10, there are multiple different ways that you can do that. You can do 2 + 8, you can do 5 + 5, you can do 6 + 4. So you sort of have to sort of have a broader number of questions often to start with, because you want to be able to test it over multiple times. So it's one of those things where we've got a lot of ideas in here, and then we can extrapolate smaller parts out of it over time. But I don't need to explain test design. So what we did was we did a thing called factor analysis. So we looked at how all the questions related to each other and whether or not it related to one particular concept. And we were able to find that there was a strong correlation that we were actually testing one idea. Then what we did is we looked across to see whether or not there was a relationship between the knowledge, skills, the ethics, and the D is professional development, so things like reflective practice. And we were able to see that there was a strong enough correlation for us to say, yes, this is a thing. And this is one of the original analysis in terms of looking at the levels. So you can see there in terms of all the responses, we had the different levels, the little stripes that were there. And so we were able to see that the one down the bottom was right at the bottom, that tended to be behaviors that you go, that wouldn't meet the threshold. The first level, where it's got like 0 logits, you sort of got a line there. That was the very beginner. And then we had a second level, which was a little bit higher. And that's where we decided that we would have like a sort of a basic level, but then we would say, actually, we want people to spend some time in a provisional role, and then that we would expect that next level. And then that highest level, they were the ones that tended to be the very experienced practitioners. And we looked at the individual questions, the patterns of the curves. So that was, this is how the different answers related to each other. And then what we did, so these are all of the knowledge questions. And what we did was we looked at where there were certain jumps And then we were able to cluster all of those things together. So we weren't fixed on which bits of knowledge had to go in what level. We looked at the data and said, all right, these things all tend to be together. These things look like they all go together, and these things all look like they go together. So this is a technique called item response theory. So we do a right map, it's rash modeling. So it's things that have been used to develop progressions and psychometric profiles for a long time. And the idea is that you've got this progression of skills and that you can locate a person along any one of these points. So that's essentially how we did it. So it's a mixture of the way that it's done is it's sort of a mixture of qualitative elements in that you're using people's you've got a long bit of text. It's not just like it's about behaviors, and it can also be observed. So if you're out with the skills, you can watch somebody and do it, which tends to be more of a judgment based rather than an objective assessment. But because of the way that you can record the information, you can then turn it into a quantitative process.
Thank you.
So I'll stop there. That's for all the data nerds out there.
All right, thank you very much. We weren't able to get Mr. DeBow in, so if we do get him later, then we'll just take you up on your offer, Ms. Hutchinson, for him to reach out to you. So thank you so very much for taking the time, like I said, and I know it's a very early hour for you. So
Thank you. Thank you so much for the opportunity to share what we did here. And I wish you all the best. And if there's anything I can do to help, please let me know.
Okay, we will. Thank you. All right, we're going to move on at this time to item 2.5. And this item is being presented by Dr. Jack Getz. And you've all received an executive summary of this presentation. And so I'm going to ask that we watch our time and that we have discussion following his presentation. So Dr. Getz, would you please proceed?
Thank you, Judge Bashan. Okay, can everybody hear me?
Yes.
Good. All right, so I am lucky because I had a great subgroup, and I just want to mention their names so you and invite them to comment after I presented what our consensus was. But Paul DeBow, Sarah Hodgson, Ron Kelly, Katie Jones, and Eric Tuckman, all of whom participated, were engaged. We covered, we think, almost all the issues that could be covered in the topic, and had people open enough to change their minds about things after listening to the discussion. So I'm happy to report we reached consensus on some items, and I'll just go through them briefly because I know they're summarized in the report. But well, first, as reported, we did reach consensus on a complaint procedure that, again, as the legislation requires, that would be substantially similar to the existing California rules of court, and that we believe could work for arbitration and mediation. Alan Weiner took the lead on generating the initial draft and making changes that were responsive to the dialogue of the subgroup. I focus on arbitration and mediation because we left it open as to whether it would work for other forms of ADR. The subgroup believed we just didn't have enough information before us that we could make that decision. So we do believe the complaint procedure could very well work for arbitration and mediation. And again, substantially similar to the California rules of court. And then, so that was one consensus. And then second consensus arrived around who should be the group or entity that processes the complaints. We spent a large part of our 2 meetings, particularly, we had 2 meetings since the last working group, particularly the last meeting, discussing the complaint procedure, whether the complaint procedure should be conducted by the practitioners themselves or their firms or through parties with which they have a business relationship. And the consensus at the end of the day was that the state bar or a professional organization designated by the state bar would serve the certification best. There was acknowledgement that some firms have already developed a review process that has worked very well for them. There's nothing about what we reached that wouldn't allow the firms to continue that process. But in weighing all the considerations as to what we should do for the certification, that ultimately led us to conclude that the state bar or professional organization designated by the state bar would serve the certification best. We discussed things like the appearance of impropriety, including the fact that most of our ethical codes for arbitration and mediation and the California Rules of Court have requirements about disclosures and prohibitions that prevent us from handling matters that concern us and being in a business relationship with an entity deciding these matters would have, we thought, at a minimum, the appearance of impropriety. We also discussed the potential lack of public acceptance of any resolution handled by practitioners themselves or entities with which they have a business relationship. We didn't think that would go over very well. There was a lot of talk about the impracticality for sole practitioners, particularly, to command the resources necessary to process the complaint procedure. And then we also just talked about a practical standpoint of the potential uneven application of the procedure if it's handled by multiple organizations rather than a single organization. And that doesn't list all the things we talked about, but it was certainly robust, and we came to the consensus that it would best be that the state bar or professional organization designated by the state bar would be in the best position to handle complaints under that complaint procedure, again, with the limitation that we were speaking mostly to entirely really into arbitration and mediation. We just didn't have enough information on the other ADR forms and whether it would work. That's the brief consensus. I don't want to take up any more of our time with going through what was a very thorough report, but I do invite any comments from our members of our subgroup first. If you had any comments, I would appreciate it. And then we can go forward and discuss it as a whole group.
Okay, before we have comments from members of your subgroup, Dr. Getz, I'd like to tell you thank you for your leadership, and also thank you for your report on the complaints and remedies subgroup. So if you'd like for any of your members to speak for a minute or so, that would be fine. And then I'm going to go to Ms. Doherty and Mr. Weiner for their suggestions or reports. Anybody from Dr. Getz's group? I did see a hand flash by. Yes, Mr. Kelly?
I think I'd like to reserve my comments until I hear what staff has to say, because they have their own views that I think are potentially very influential. So I would like to speak about it later.
Thank you. I appreciate that. So let me go then to Ms. Doherty. Is there anything that you would like to say based on your attendance in that group's meetings?
No, thank you, Chair. I think that Dr. Getz captured it quite well. And I do, well, I'll just additionally thank the subgroup for their active participation, along with all of the other subgroups, so that this doesn't turn into me using a lot of our limited time to thank everyone.
Absolutely. And Mr. Weiner.
Thank you, Judge Bashan. I would echo what Dr. Getz said about the subgroup working well together and reaching consensus. I just thought it would be helpful. Dr. Getz mentioned that I prepared the initial draft. I thought it might be helpful for the full working group to understand how that was done. The statute said that the complaint procedure that's required needs to be substantially similar to the rules of court governing complaint procedures for court program mediators. And so what we did, and incidentally, Mr. Kelly was on the working group that developed those court procedures. What I did initially was I took that complaint procedure and I started redlining it and taking out the references to courts and putting in blanks, not knowing whether it would be the state bar or who would be carrying out the complaint procedure. And then through, I think, a couple of drafts, the subgroup kind of filled out some of those, filled in some of those blanks. And some of the answers were guided by the conclusion that Dr. Getz mentioned, that it should ultimately be the state bar or professional organization that was approved by the state bar. The other thing I just wanted to mention, Dr. Getz noted that the subgroup thought the complaint procedure is suitable at least for mediators and arbitrators, but didn't go beyond that at this point. Part of the reason for that is that the statute does not reference ethical standards for any of the other types of ADR practitioners, including referees and conciliators who are specifically called out in the definition of ADR. And so in the absence of knowing what the ethical requirements would be, it would be difficult to determine whether the complaint procedure would be suitable for addressing complaints about those. I think the subgroup will need to, or a different subgroup will need to grapple with that at some point in time, once we know what ethical standards we're talking about. And I would add that there's further challenge around that because the statute says that at least for tiers, the ethical standards can only be those referenced in the statute. Thank you.
Okay, thank you, Mr. Weiner. Now for comments from the subgroup and Mr. Kelly.
Thank you. I have a general comment which would apply to this particular one and to all of the reports from the subcommittees. Staff asked us as a subgroup, and I assume other subgroups, not to share drafts of this with other people because it might be modified. Excuse me. So that means that the public has had very little time to read these. I'd like to ask that we take at least until our next meeting for the full working group to actually approve these, so that some of us can go back, talk to our various constituencies, professional organizations, and see what they have to say about these now that they're public. The other reason I would suggest to do that is because in hearing Dr. Getz's summary, I think I misunderstood a very key element about this, which was who was going to hear complaints. I thought it was going to be the state bar or any professional association that the state bar is certified, so that I might be able to go to a professional organization that I knew. Somebody in Southern California might be able to go to one that they knew. And I'm not sure that that was at all clear from the wording of the draft that's coming now to the working group. We also didn't deal at all with who pays for this. How is there going to be a complaint coordinator with the experience to handle a large volume of complaints, at least about arbitrators? We don't know how it's going to be funded. So I think there's some holes anyway that would, I hope, mitigate against the entire working group saying, yep, we like what you've done. We approve it. Thank you.
All right, thank you, Mr. Kelly. Anyone else with comments from the subgroup? I don't see
Yeah.
hands. Is that you, Dr. Getz, saying you don't see any hands? Okay.
I actually would like just to make a quick comment. And maybe I could use Erica and Ms. Doherty to help us with this. Is my understanding that the public is going to have a lot of time to go over all of the working group product, that what we're releasing eventually will in fact be out for public comment for some period of time. But again, I'm novice at this process, so I'd invite you to comment, and specifically going to Mr. Kelly's comments.
Sure, happy to. I'm just going to note, I continue to see Paul's hand going up periodically. I think what we're going to try and do is admit, Angela, if you can, Paul, whose last name I cannot see, and then assuming it is Mr. Dubois, we will obviously have him stay. Do you mind doing that, Angela? Because he was on this subgroup as well, and I don't want him to miss out on the opportunity to participate.
Yes, I just promoted him.
Okay. Paul, is that you? Oh, good. Okay. Great news.
Okay, can I speak?
Let Dr.
Well,
Getz, do you want me to answer that quick public comment question, or how would you like to
Yeah.
proceed?
Well, I just wanted to, about Ron's concern about the payment, about this cost. I thought I had suggested something. I'm not sure that it was part of Jack's presentation. I think it was, but I had thought that that these people who were doing the work, well, first of all, if the state board did it, it wouldn't apply if we had to hire an outside agency. But if the state board did it, I had proposed that we get some volunteers who are neutrals, either mediators or arbitrators, and train them, and then they would do this work. Very similar to what we do with the mandatory fee arbitration program, where the arbitrators in that are volunteers and are not paid. I think if we did that, of course, we probably would have to hire at least one more state bar employee, but these extra costs could be subsumed into the cost of the program because as the statute provides, that any costs to the state bar will be part of the fee that the people who want to be certified will pay. So that was my proposal, and I don't know if it's officially part of the our report, but that's what I would suggest.
All right, I see. Thank you, Mr. DeBoe. I'm glad you're here. So I see.
So am I.
Mr. Weiner, I see your hand, but Ms. Doherty was speaking, so I'll go back to her, then come to you.
Okay, thank you, Judge Pichon. So to answer the Dr. Getz's question and to be responsive to Mr. Kelly's issue concerning making sure that the public has the ability to, an opportunity to participate. It is intended that the this working group would essentially be able to vote out for a public comment opportunity its recommendations before it goes up to the Board of Trustees, meaning that whatever recommendations the ADR working group has, they would get an additional opportunity after the public comment period to make any modifications that they deem appropriate. And then once the recommendations are presented to the Board of Trustees, whatever the board essentially authorizes for public comment would then go out for an additional public comment period. Now, to Mr. Kelly's point, I will just say that the benefit of posting materials in advance of the meeting is that people can view them, and if they wish to give public comment at this meeting, they can do so. Given the timeline associated with the last subgroup, as you've probably seen in the memos, didn't meet until end of day, essentially last Thursday. And so just to get these posted for this meeting required a bit of staff time to get them posted. So that kind of explains a bit more the tighter timeline as to when those memos were posted.
All right, Mr. Weiner.
Thank you, Judge Pichon. I just wanted to kind of respond to what Paul had mentioned about his proposal for how the cost might be covered. And part of the challenge that the working group and the subgroups face is there are a lot of interlocking pieces. There are going to be a whole lot of questions down the road about how the program is going to be administered once it's set up, including what the application process is going to be like, how the applications are going to be reviewed, how complaints are going to be reviewed. Specifically with regard to that the draft complaint procedure has some bracketed text where it says complaint committee, and I think it says words to the effect of that this will be determined down the road and clarified later in the process. So it was just too big of a bite, we felt, for the working group to take on that administrative piece at this stage.
Thank you, Mr. Weiner. And I saw another hand. Was that you, Ms. Ellis?
It was me, Madam Chair, but I realized I didn't know if you had opened the floor yet for non-subgroup members too.
Oh, okay. Well, let me check. Are there any other members of the subgroup who'd like to speak? All right, Ms. Ellis.
Great, thank you. And thank you, Subgroup on Complaints and Remedies, for your hard work on this. I did agree that the proposal is substantially similar to the California Rules of Court, which do leave, I think, as Mr. Weiner just mentioned, a lot to individual courts in terms of implementation. And so I had questions surrounding that. Maybe they're not appropriate for this time, but I did agree with the public comment we received about questions, for example, of complaint timeliness and things of that nature. You know, if a complaint is filed many months after a mediation, what the effect of that might be. But I don't know if folks wanted to speak to that or save it for later. Thank you.
Okay, thank you. Mr. Polewski.
Well, I thought this was a really good report, so I thank the committee. I just have a question about remedies. I'm not really clear what the powers or the remedies would be upon a finding of a violation. I see it in section 6, you can admonish or reprimand or revoke a certification, but is that it? Basically, sort of a scolding or the elimination of certification? Are there any other repercussions from somebody acting unethically after a finding?
Let's see, Dr. Getz, I don't know if you want to take that or staff would. Oh, I see Mr. Weiner's hand up.
Yeah, if I'm happy to, if Dr. Getz wants to defer to me.
Yes, I do.
Yeah, thanks. I think that it raises a question. I mean, I'm not quite sure, Mr. Polewski, what you would envision as other remedies might do, but let's just say, for example, that you're thinking of monetary relief. You know, perhaps an ethical violation caused economic damage to someone. I'm not sure that the state bar or that any other complaint handling organization other than the courts would have the authority to award damages, if you will, or to award any type of equitable relief. I suppose it would be possible that the state bar could recommend that a person who against whom a complaint was determined to be founded could recommend that they provide relief to someone, but I don't think that would be enforceable. But I think it's a great question that you raised.
Yeah, I wasn't looking for any particular remedy, and certainly not a procedure where money is being awarded, but I see that there's something here about someone not being allowed to do other adjudications. I guess that's related to the complaint. But I'm just thinking about it in terms of public protection, that if in fact you find somebody who really shouldn't be doing this kind of work, what are we going to do about it?
Well, I think the extent of the state bar's authority is the decertification. Frankly, I don't think that the statutory system provides for this certification program to prohibit someone from engaging in an activity that a license is not required for. You know, with other professions where a license is required, you know, that is one of the remedies that is available. But I'm not sure how that would be available in this context.
That's what I thought.
All right, thank you, Mr. Weiner, and I see Judge Lucky's hand. Yeah, and you're muted.
Thank you. I wanted to follow up on what Alan said, because I think that that certification is the scope of what we're examining and what our charge is. And so the decertification I would see as being the remedy. But one of the things that I think we could do to kind of send the signal is when you look at somebody's state bar webpage, and it will say prominently whether there is a history of discipline, and maybe what the additional sanction could be is not just that you're taken off the list of certified, but that there is some way for the public to look up that you were certified and then were later decertified. And maybe that is, that doesn't get to an additional sanction, but at least in terms of public protection, it would allow us to show that someone was not on the list because of malfeasance or nonfeasance, as opposed to has never applied.
Thank you. And I see Mr. Tuckman's hand.
Yes, thank you, Chair. And this is just in reaction to the comment about other ways of providing notice that somebody might have been found to have violated the ethical standards that exist here. But again, I'm wondering how we might do that where some arbitrators might not be members of the State Bar of California, or perhaps they're admitted to the bars of other states, or perhaps they're not lawyers at all. And if you therefore might be creating sort of a different standard in terms of the impact of such a finding for those that are members or not. We did discuss these issues as well in some respects during the meetings. I don't know if there's consensus that we do need to find a way to do more. I think sounds like there might be room for it, but it's a little tricky.
All right, thank you. And Mr. Pileski, your hand is still up. Did you want to speak again?
I did. I didn't mean to jump ahead of anybody, but yeah, it occurs to me that I'm thinking more in the arbitration context in my thinking. But there's a court created immunity that seems to extend to arbitrators and providers up to a certain extent. And I haven't thought this through. I'm just thinking about it now, but maybe there's something that can be done regarding the immunity for violations of ethical rules, as opposed to bad decisions or normal run-of-the-mill adjudicatory decision making. We can think about that.
Okay, thank you. Mr. Yamsham.
Thank you. Reflecting on Eric's comments, you're absolutely right that the state bar's jurisdiction over non-lawyer neutrals certainly would be severely limited. For lawyers who arbitrate in California, one must maintain their membership in the state bar. The question is about out-of-state lawyers who come to arbitrate cases in California. I don't think there's any pro hac vice requirement for them. And I'm not sure that the state bar could assert that jurisdiction. So, and thank you for your comments, Eric. I think they were very productive.
Thank you. Ms. Doherty.
Yeah, I just want to point out, I think what's being referred to by everyone is the My State Bar, the licensee search and My State Bar profile information that shows up for attorneys. And just to level set for those who may not know this, so on an attorney's profile page, it shows two things. It shows public record of discipline, and then it shows any administrative inactive enrollments. And that can be, failure to do your continuing legal education on time, failure to pay your licensure fees, a whole host of things. And then in addition to that, public discipline. We're not there yet, but I don't think what anyone so far has suggested is that every practitioner or provider or firm would have their own certified page, profile page, essentially on the State Bar website. What we do for other certification programs that we do is there is essentially a directory of those who are certified. So it's not an individual page, but it's kind of a longer scroll through that's sorted and such that includes that information. So that kind of registry, if you will, could include the individuals, provider organizations, firms, et cetera, that have been certified. And then the flip side of that, to Judge Lucky's possible suggestion, is they could either be removed altogether, or it could indicate perhaps decertification of some kind.
Thank you, Ms. Doherty. And Mr. DeVoe?
I just wanted to respond to Dan Yancey's concern. I think under, I think it's 1281.4, it's 1281. I can't remember the exact section of the Code of Civil Procedure, but there's a section in there that if you are an out-of-state attorney who appears in an arbitration, you have to be approved. You have to file a form with the state bar And if you are approved, you also agree, I believe, that you would be agree to be subject to state bar discipline for activities surrounding your arbitration appearance.
All right, thank you, Mr. DeBoe. And Mr. Weiner?
Thank you, Judge Pashon. Responding to this chain initiated by Judge Lucky's comment about sort of ramifications, I just want to note that the rules of court did give the courts the authority to either publicly or privately reprimand somebody who was found to have violated the standards. Staff was of the view that reprimanding was not something really that the state bar would be likely to do, but that if somebody is certified for a year or two, for some period of time yet to be determined, that the remedy would more likely be to decertify the person, either with or without the ability to reapply for certification in the future. I think if the working group felt strongly that the state bar ought to have authority to publicly reprimand, I think that's something that Erica could speak to, is whether that's feasible or not. But that was an aspect of the court rules that these were modeled after.
Thank you, Mr. Weiner. We're running short on time for this particular item, but Mr. Kelly's comments are still out there. And your request, Mr. Kelly, was to put this over rather than take the vote. I'm going to refer to staff, refer this to staff, but and I know you well understand what we're going to vote on or what we intend to vote on. And that's just whether the state bar, the complaints would go to the state bar or a professional organization designated by the state bar. So Mr. Kelly, do you still have your request out there?
Well, there's two aspects to it. I didn't understand, and I still don't understand, whether we're talking about a single entity that is either the state bar or some single entity that the state bar designates, or whether we're talking about, for instance, me as an individual practitioner, can I say I'd like MC3 or the Mediation Society or some other professional association to be my complaint handler if it's one that the state bar approves. So I'm a member of the subgroup. I don't know that I'm prepared to vote on saying yes, I approve all of these. But the other one was, I'd like to go back and talk to a bunch of people about how they feel about this before I vote. So there are two aspects. Thank you for asking.
Oh, sure. Mr. Weiner?
Yes, I'm sorry. Recognizing the shortness of time, I just wanted to say that my understanding of the subgroup discussion was that the state bar might approve multiple organizations to hear complaints, but not, and that if one of the organizations that Mr. Kelly wanted to have his complaints heard by was approved, then that would be fine, but not that, and maybe Mr. Kelly might suggest that an organization be approved, but not that if a complaint came in about him, he could simply say, well, I want this complaint to go to, and then initiate the approval process. So I see Mr. Kelly shaking his head. I hope I've clarified at least what my understanding of the subgroup's recommendation was. Thank you.
Okay. All right, great. Thank you for that clarification, Mr. Weiner. Mr. Kelly, are you ready to move forward?
My second feeling is still in effect that I'd like to talk to a bunch of people how they feel before I vote, but maybe everybody else already feels ready to approve it.
Okay, so let me check. Thank you. Let me check on that. So Mr. Weiner and Ms. Doherty, as far as talking to people outside, what are our rules of order say?
So this meeting is public, and the documents that were associated with this meeting are also public. And so Mr. Kelly or anyone on this working group or outside of this working group, frankly, is able to take that public information and kind of do with it what they will.
Okay. Yes, Mr. Weiner.
I'm sorry, with apologies for jumping in again. Just I'd like to explain the sort of the reason for the suggestion to work working group members that they not discuss it. You know, in my experience, you know, over the years in developing rules like this, a topic sometimes comes up and the subgroup is, or the working group is considering it, and it may never come into fruition, but it may cause a lot of alarm, or people may think, oh, that's absolutely great, but that may not be the recommendation. So when there's a public comment process, such as this process affords, both at these meetings and later when things are distributed, sometimes it seems advisable, and it's up to the working group really whether they agree that it's a good idea, you know, to refrain from discussing until there's something on paper.
Okay. Well, let me do this. Everybody has heard the report from Dr. Getz. We've had discussion here, and also let's see. Oh, we can just see if the rest of the working group would like to go ahead and take a vote. We'll take a straw vote on whether they would like to vote on the recommendations from this subgroup, and then we can go forward. Why don't we do that? So the question is, would this working group like to vote on the subgroup's recommendations that have been listed in the executive summary and that are in the agenda for today? So may I, Ms. Doherty, should we just raise our hands? Did you?
That's correct, but however, that will be very hard to capture in future meeting minutes if that is the will of this group. So if that is again, straw polls are typically not things that are captured in our meeting minutes as an organization. But if that is the will of the group, I would encourage you to structure this in a way that we can actually vote on things.
Okay, yes, I see Dr. Getz's hand.
I appreciate what Mr. Kelly has proposed. What I'm confused about is if that is true for this group, it's going to be true for all the groups. And if that is true, then we won't have any final votes on anything. And I notice on our agenda, we need to talk about subgroups, new subgroups. So I don't know how this, you know, procedure of waiting till our next meeting to vote really affects the whole process. I really need, I guess I have to rely upon staff to you know, opine in on that one.
Okay, thank you. And Mr. Dubois.
Well, why don't we just vote on this and with the caveat that it can always be amended.
Okay.
And,
yes, that's
and
perfect.
then we'll just vote, and if it passes and people don't like it, we'll amend it.
Okay, thank you, Mr. DeBow, for that. So what we can do is I can just ask the question, is there anyone of the working group who does not want to vote on the recommendations of the subgroup? Okay, I see one hand. Is there anybody else? Okay, thank you. Oh, Ms. Curtis, you go ahead. You do not. I'm sorry, you're muted.
Yeah, I just don't feel prepared to vote because I don't have enough information. That's all.
Oh, okay. All right. Two. Anyone else? Okay. Well, as much as we'd all like to be together on where we're going. Ms. Curtis, do you?
Oh, no, I just.
Okay, that's okay. We'd all like to be together. I'm gonna go with the consensus. So we have two people who do not want to vote on the recommendations of this subgroup, but everybody else seems to be in favor of voting. So we're going to move ahead. Although I'd like to take everybody with me, I guess I can't do that. So the first is complaints about certified firms, providers, and practitioners be addressed by the state bar or by a professional organization designated by the state bar. That is what we'll be voting on. So I'm going to ask Angela, would you please take the call?
Chair, I apologize for interrupting. Are you asking for a motion on this?
Oh,
And,
so-
and a
yes,
second, or,
yes, I am.
okay,
First
thank
of all,
you.
is there a motion regarding this recommendation?
So moved.
Okay, and I believe that was Dr. Getz.
No, that was
And
Daniel
Daniel.
Yameson.
Okay, okay. I just couldn't see you while you're talking. And is there a second?
Jack Lucky, second.
Thank you very much. Any further discussion?
Madam Chair, can I offer a friendly amendment to the motion?
Sure.
I just wanted to confirm that we're voting for either the state bar or one or more entities certified or agreed by the state bar to serve this role.
I'm gonna ask Dr. Getz.
Defer to Alan Weiner on this.
I
Okay,
believe that was the understanding of the working group.
okay.
I mean, of the subgroup, excuse me.
Thank you. Ms. Kopelkin?
Yeah, Bacon, I'm sorry, I think that when you read it out, I have to put myself into the list of I'm not sure I can vote on this because I don't understand who it is who would decide where the complaint went. Would it be the complainant or would it be some other process? So I would feel more comfortable understanding that before I voted.
Okay,
And perhaps I just didn't track it well, and I apologize if that's the case.
okay, Ms. Kopelkin, I'm sorry, I mispronounced your name. Mr. Tuckman?
You're muted.
Thank you. There's been a fair amount of discussion about who can hear the complaints, and the state bar is one, and the idea that the state bar will designate or will be able to designate other organizations if they meet the criteria that are set. And Erica, not to put you on the spot, but I just recall during our meetings, you had a specific example. It might be helpful for the group to hear that where the state bar might have also had authority to designate other entities to hear issues. Does this ring a bell?
It
Not
does
really.
not, only because I think, are you referring to the state bar court? So that's like an additional process, if you will, after that initial review by the individual organization, by the state bar, essentially.
Yeah, I just recall that there was a model for this type of system that existed in other contexts. And I thought it might illustrate for this group how it might actually work, but perhaps that's not the case.
I think, well, I think what you might be referring to is like how the process works with fee arbitration, and the state bar is an organization that handles fee disputes and fee arbitrations as the administrator. And then local bar associations additionally handle fee arbitration and fee disputes. The state bar inserts itself essentially in that type of a program where there isn't a local bar or fee arbitration program. We talked about, I apologize, Mr. Tuckman, we talked about so many things, I'm not recalling exactly what you're referring to.
It's okay. And actually, I think that does ring a bell. I think that was the example we were talking about. So,
okay.
All right.
To the extent that's helpful here, I don't know.
All right, thank you. Now, I did see a number of hands, but now I just see Mr. Weiner's hand.
Yeah, I would, thanks to Sean. I just wanted to clarify what my understanding of the process is, which is that anything that's adopted by the working group at this point is going to go out for comment multiple times. As well as people being able to comment at the meeting, it'll go out and we'll solicit written comments, which will come back to the working group and perhaps back to the subgroups from there. And then my understanding is that when the subgroup makes, if you will, a final recommendation to the State Bar Board of Trustees, the State Bar Board of Trustees is going to also send it out for comment, and that'll come back to the working group. So I would almost frame it as a tentative approval, if you will, that, we think this is good enough to move forward with at this point in time.
Thank you, Mr. Weiner. All right, so I did ask for a consensus, and I asked if there were people who did not want to go forward with the vote. And there were two, but it seems like a few people have changed their minds, which is absolutely fine. So I really do need to know if the group would like to go forward with a vote on the recommendations of the subgroup. Yes, Ms. Doherty.
Chair, would it be helpful if I put a proposed resolution on the screen? I think there's a pending motion on the floor, but I think there was a request for a friendly amendment and so forth. Would that be helpful?
Yes, I believe it would be helpful. Has everyone had an opportunity to not only read this, but to take the time to give it some thought? If you have, I can ask if there is a consensus on this resolution for item 2.5 and ask if there are any members of the working group who would not be in favor of voting on this particular resolution. And I see Mr. Kelly's hand.
Judge
Kelly.
Pishon,
Yes.
Ms. Cruz's hand has been up for some time before you called for that last vote.
Oh, okay. Thank you. I can't,
And my apologies, I just thought that it sounded like the working group, the sub working group was amenable to Jenna's proposed change of one or more professional organizations. I think, I'm not sure it really matters one way or the other, since it could be read both ways, but it sounds like that'd make some of the members more comfortable, Judge Pishon. So maybe we could just amend it, Erica, on the fly, and then we can vote.
you'd like a S on organizations?
One, I think that
Without the S.
Jenna's suggestion was one or more, I think, organizations, and I'm not wedded to any verbiage, and I defer to the subgroup.
I
Okay.
agree on the verbiage. I am concerned that as phrased, it could add confusion, but I think if there's a way to clarify that more than one professional organization can be designated by the state bar at the same time, I think that was the concept that Mr. Kelly was discussing.
All right, and I see the change being made now. The S would, and I see the S added, so it's one or more professional organizations designated by the state bar. Is Ms. Doherty, do you mind taking it down? I can't see
No, I'm
everybody.
happy to. And I'll just, while I'm taking it down, it would be, I believe this is Mr. Yamshawn's motion, so it would require a friendly amendment and agreement by Judge Lucky.
Well, as to avoid a separate vote on the amendment, the movement accepts the amendment as friendly.
All right,
And this is Lucky again, I second as amended.
thank you. All right, so I'm going to take a vote on this resolution. I guess, first of all, we need a motion and a second. Ms. Doherty, am I following the proper protocol?
You have a motion and a second, so with your permission, Chair, Angela can take the roll.
Okay, all right. Angela, would you please take the roll?
Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois, Paul, you're muted if you want to vote.
Yes.
Thank you. Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson is absent. Jones,
Yes.
Kelly,
Abstain.
Copaken,
Yes.
Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson is absent. Tuckman,
Yes.
Welch,
Yes.
Yamshon,
Yes.
Judge Pishon.
Yes,
Motion carries with majority.
thank you so much. All right, that moves us to vote number 2, which is the tentative approval of the draft complaint procedure for addressing complaints about arbitrators and mediators. Let's see. I'm going to go first to Dr. Getz. Is there anything else you'd like to say about this one?
There was a consent. No, there was a consensus on this.
Thank you. So I'll go now to staff, Ms. Doherty or Mr. Weiner.
No, thank you, Chair.
Thank you. Nothing to add.
Okay, and anything from the subgroup members on this one? All right.
Would it again be helpful to put it on the screen for the benefit? Okay. And then while it's loading, Chair, you would need a motion as well.
Right. Would anyone like to move approval of this recommendation?
I'm happy to move it.
All right, that's Dr. Getz. Is there a second?
I'll second.
Okay, may I have your name because I can't see you?
Paul Dubois.
Thank you.
And I'll just note, I just added the word improve. We were just missing a word.
Okay, thank you. Any discussion? Angela, would you please call the roll?
Yes. Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo,
Yes.
Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson is absent. Jones,
Yes.
Kelly,
Abstain.
Copaken,
Yes.
Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson is absent. Tuckman,
Yes.
Welch,
Yes.
Yamshon,
Yes.
Judge Pishon.
Yes,
Motion carries with the majority.
thank you. All right, I think it's time for that we take a break. So how about we break until 4 o'clock?
Yes.
All right, and so we'll just mute ourselves and turn our cameras off but not leave. Thank you.
They're recording right now.
Okay. All right, so now we'll move on to item 2.2, which is the report and discussion of the baseline certification for mediators subgroup. And I'll turn this over to Dana Curtis. Ms. Curtis, thank you so much for your leadership and thank you so much for the participation of each of your subgroup members. We do have the executive summary of the report and we've all read and considered it. And would you please proceed, Ms. Curtis? Thank you.
Thank you, Judge Bashan. Well, I'd first like to thank our small but mighty group, which spans a wide spectrum of practice in mediation, and also a wide range of opinions and viewpoints. So I'll get to the fact that we did reach consensus on some things, but I wanted to give you a sense about how we got there and what our meetings were about. So since we met last in in March at the working group, we met twice. And both times we had all of our members present. The first time was on April 17th, and Alan was there, was on March 26th when Alan was there, and the second time was on April 17th, just last week, when both Alan and Erica were present. Thank you both for your guidance and participation. So the first time we met, we talked about what had occurred in the subgroup previously. In the working group previously, and some of us were reluctant to move forward to discuss mediator qualifications until we had a better sense of what the legislature intended, and if in fact we were confined to the three enumerated issues, the requirements of 6173. We ended up, and some of us wanted to go forward and talk about the mediator rules of conduct. And so we compromised or at that point, we weren't ready to do that. So we agreed to adjourn, and in the meantime, to consider a couple of documents. One that was being prepared by Alan and staff, and that was a summary of the requirements of various court programs throughout California, court-connected programs. And then the other document was one that was actually created in 2010 as model qualifications for mediators in court-connected cases. So we all took a look at that, and we came back to our April 17th meeting to discuss mediator qualifications beyond the three that we've already been talking about, and again, we didn't have information from the legislature, but Erica had mentioned that that outstanding was a request for general counsel's opinion, statutory interpretation on the issue. So we agreed as a compromise to divide half of our time to consider mediator standards of conduct and the other half to consider mediator qualifications. So as to the first, I'll just report that we had some discussion following. I had mentioned that I had gone through the rules of conduct and noted where I thought we might want to discuss elaborating or even looking at some new rules. And so my group asked me to list those, and that's what sort of created our issues list, which isn't complete, but I wanted to just give you a heads up about the kinds of things we're thinking about, or will be. So the first had to do with coercion. The second had to do with the part of the rules that concerned withdrawal from mediation. Also having an eye toward including social media, since this was granted, or since this was passed so long ago, confidentiality, and disclosure and solicitation. So our discussion really focused on, which will continue, focused primarily on whether mediators should be required to disclose prior mediations in which a party or a counsel appeared. And there was some difference of opinion there. So we'll get back to you on all of that. Regarding our discussion of mediator qualifications, you might remember that we had 6 that we outlined as having reached consensus on in our first subgroup meeting. I won't go into all of those, but we did decide to discuss both training and development. And we began with training, and we agreed that the other 4, which were point system and alternative paths to qualification, application, documentation and verification, complaint procedures and remedies, and renewal and recertification requirements, would all be either subsumed in the first 2 or handled in the recommendations that we made on rules of conduct, or perhaps on the administrative procedures. So in terms of training and development, we came up with some recommendations. We were focused on making sure that we could communicate something about qualifications to the public such that they would be able to find meaning in the certification process. And we also didn't want to, we wanted to be alert to the various paths and to have alternative paths to entry, but not that were so minimal that they were not meaningful. So I guess, Erica, you have a slide of our.
I do, and I will screen share. I will just let you know, you all received an email that something got posted at the very last possible second, and that was just these tables. So there's one for each of the subgroup recommendations and an attempt to combine them, just for those of you like myself who may be better at seeing things visually. So that was what was posted, and apologies that it was posted so late, but we were trying to figure out a way to best display this information.
Okay, and just I forgot to mention that we patterned the training requirements, the content on the model qualification standards for mediators and court-connected mediation programs for general civil cases. The document I mentioned earlier is having been adopted or promulgated in 2010. And then I wanted to give a chance for Erica, you and Alan to say anything you wish about staff's perspective, maybe now or after we're done reviewing these. Do you have a preference?
I think you should go ahead if you, yeah.
All right, so we ended up with 3 options, and these aren't to be confused with tiers. Options is a very deliberate term. So the first would be that you've completed 40 hours of training within the past 2 years. Option 2, completed 40 hours of training, mediation training at any time, plus 7 hours of continuing or advanced training within, I can't see it, but I think it's 2 years. I don't have it up here. Let me get on my own.
That's correct.
Yeah, okay. And also option 3, complete at least 25 mediations within the past 2 years, plus 7 hours of continuing or advanced mediation training within the last 3 years. Am I guessing? Am I getting that right?
It also says 2 for the training.
Right, I'm sorry. So, and then you see the asterisk there, which identifies that at least that at least 25 of those 40 hours must be in a single comprehensive program. And we recognize that that is not, that a 40-hour training has been the convention for a very long time, but that DERPA has a requirement of 25 mediations. And we discussed whether DERPA needed to think about, upping that requirement. But at the time, we wanted to make it possible for DERPA mediators to seek certification. So that was the reason behind the 25 mediations within the, that's with the 25 being continuous in a comprehensive program. And then we provided the following requirements that the following content be included, and that is conflict communication and mediation theory, stages of the process, mediation and communication skills and techniques, mediation ethics, mediator ethics, the law governing mediation, including confidentiality, and observation of mediation demonstrations and participation in role plays. So, and then also that it must include training on the rules of conduct, culture, gender issues, and mediator roles in drafting agreements. And so we didn't address this issue of requirements. It doesn't mean there aren't going to be any experience requirements. There will be. We'll take that up at our next subgroup meeting. Thank you. I want to know if I want to hear from you and Erica and Alan, but also from any of the subgroup members who want to elaborate on our deliberations or rationale or have anything else to offer.
Ms. Doherty or Mr. Weiner, do you have anything that you would like to add?
In the interest of time, not that's, well, I don't, not that's not reflected on the screen, but I wonder, should I stop sharing so that everyone can see each other again? Would that be helpful? Okay, I see nods, so I'm guessing that's a yes.
From a staff perspective, Alan and Erica?
Thanks, Ms. Curtis. Yeah, I'm just quickly to touch on a couple of things. Ms. Curtis mentioned the model qualifications for courts. I just wanted to note that those were developed in by the Judicial Council, a working group that included many members, esteemed mediation trainers, and court folks, and others who are kind of skilled in that area over a period of much more time than this working group has to perform its task. That was probably at least or close to a 2-year process just to come up with the model qualification standards. And the other thing that I wanted to mention, and maybe Ms. Doherty would have, but maybe this will preempt it. So staff supports the subgroup's recommendations on the training qualifications, the 3 different options or pathways that Ms. Curtis has summarized, with the condition that those requirements be paired with some experience. And so staff is of the view that for certification, an EDR practitioner needs to have a combination of training and experience. And the more training, the less experience, and the more experience, the less training. So that's all I would have to add. Thank you.
All right, thank you. I see Ms. Jones, his hand is up.
Yes, thank you. I had a question about if these same qualifications would be applied to recertification. I know that it's like a 2-year period we're looking at. Is there some discussion that the recertification would be on a 2-year period as well? I was just curious about that. Perhaps it's not the right time to ask that question.
May I just address it quickly?
Yes, Ms. Curtis, thank you.
We didn't take this up, but I'm sure that we will, because we had touched on it previously, and also it may come under administration as well.
Thank you. I saw Dr. Getz's hand up for a second. There it is.
Just along the same lines, I would be in favor of a recertification process, and I hope that's included in the future subgroups work, or in some other subgroups work, because without it, the state bar would be perhaps 3 years, 4 years, 5 years down the line recommending people who are retired from the profession, not necessarily recommending, but listing as certified. So I think it's sort of a must of most certification groups to have some sort of recertification process.
Thank you.
Just to quickly respond, the 2 areas that we did discuss early on but didn't get back to were recency in terms of qualifications and continuing obligation for mediation education.
Thank you. Mr. DeBow?
I have 2 questions. Number one, with respect to the requirement of 25 mediations in the last 2 years, that is 1 month mediation a month. That's easy for a person as a full-time mediator to accomplish, but there are a lot of arbitrators who also mediate. They primarily arbitrate, and sometimes they may not be able to achieve 25 mediations in 2 years because of their arbitration practice. And I wonder if there's to be some accommodation for that. And the second question I have is, how do you handle a person who sort of slows down? In other words, either because he's tired or she's tired, or because nobody wants to give him any business. And they only do one. They meet the qualifications initially, and they sort of stop mediating and may do 1 or 2 a year, but they remain certified. Is there a system that you've thought about to cover that?
Well, I think if you'll notice that the requirement of 25 mediation applies only to people who have not had a 40-hour training. So if a mediator is slowing down but has had a 40-hour training and also had kept up with continuing education requirement of 7 hours in 2 years, which doesn't seem very onerous, then it's possible for them to continue to be certified. Does that answer your question?
No, because what happens if they're not working anymore? Suppose they're not getting business because they're not good, and so they're not getting business, but they can say they're certified even though they're only doing a few a year.
Well, that goes to the experience requirement. I think we'll be taking that up, but thank you for that, reminder. And also, the reminder previously of recertification requirements, which I think gets to that issue.
Okay. I saw Ms. Coulter's hand first and then Mr. Dinkin.
I'm sorry, Judge Pichon. I felt like Ms. Curtis answered that adequately.
Okay, great. Mr. Dinkin and then Mr. DeBoe.
Yes, I was curious under option number 3, the 25 mediations in lieu of training, why the subgroup felt the need to have an option that didn't include basic training as part of the qualification for certification. What was the rationale behind that?
Ms. Curtis, if you want me to answer that,
I was going to ask if someone else wanted to.
We had a robust discussion about that in our committee meeting, really considering the fact that we have some very seasoned mediators who are also attorneys who have been mediating for many, many years who never took that 40-hour training. So we're trying to consider the fact that they've been mediating for over a decade, and yet now suddenly they're not qualified to be certified. So how do we create a pathway for them to be a certified mediator without forcing them to go through an additional 40 hours of training? So that's some of that rationale to make it more accessible to them. But to the points that have been made, we did not talk about recertification, and it's clear that it's something that we do need to continue to have a conversation about.
Thank you. Mr. Dinkin?
Yeah, I was just thinking, part of the purpose of the certification process is to gain, the confidence also of the public. Just logically, if there was a question about a mediator, one of the first questions I think the public would ask is, well, what is your level of training? And if someone were to say, well, I've never been trained, I've done a lot of mediations, but I have no training, I think that would undermine the confidence of the profession. And even if someone, in my view, have been mediating for many, many years, to not go back and take a 40-hour training, maybe they should do that, even though they've been mediating for many years, because that seems like such a fundamental and thing to have, and not a high burden for someone who is holding themselves out as a mediator to have accomplished.
Thank you. Excellent points by everyone. Anything else? This matter is just on for discussion. Is there anything else anyone would like to say?
Judge Pichon, we have Daniel Yamshin and also Ms. Cruz.
Oh, okay. And
You can see them.
I don't see any hands on my screen, but please, Mr. Yamshan.
Okay. Thank you. This is the last place in the world where conflict should arise. But in response to Stephen's comment, which was certainly reasonably thought out and rational, I've been mediating since 1987. I have over 1,200 cases in my conflict check database. No one has ever asked me if I was trained or where I was trained. Now, it's on my CV, at least the initial training, but I haven't added other trainings since then. So I'm not sure that that should really be an impediment. Plus, I agree that there's some outstanding neutrals out there they just understand conflict, they understand process, they know how to actively listen, all of those things, and they're outstanding neutrals. That's all.
Okay, thank you. Was it Ms. Cruz?
Thanks. Yeah, two questions. So it sounds, Dina, like you all are still talking, and then there's going to be an additional set of requirements on experience that are added to this. Is that, so we're just talking today?
Yeah, I mean, it's certainly up to the working group, but I think without having the whole picture, it would be difficult to make an informed decision.
Yeah, no, makes sense. So there's going to be more things that you're going to add to these. Okay, got it. And then I guess I'm wondering where the 7 hours and the 25 mediation number comes from. Does that come from the court approved? And I'm just wondering why 7, why 25, and why that those specific hurdles were the working group thought were appropriate.
Like, well, we had some discussion about it in terms, but we wanted, if there was not a training requirement, you know, we intended that option to be available to people who had a long-standing practice and who were, you know, actively mediating. And I think just, you know, as we talked about a little bit earlier, as Mr. Yamshin mentioned. So that was the 25. It didn't come from anywhere in particular.
And then what about the 7 hours? Why was that the magic number for 2-year training?
Does somebody else recall what
Yeah,
that?
if I can answer that, Ms. Curtis. So that was from the model qualifications for the court mediation programs, the 7 hours. Also, some of the specific content of the training were from that document that the esteemed working group had worked on for about 2 years.
Got it. So the 7 hours is from that big, long, steady Allen, but the 25 was not.
That's correct. The court program did not have that pathway, if you will. They had training requirements, I think, for, you know, for all the pathways. And as I think has been mentioned, there was robust discussion in the working group about whether there should be a pathway for somebody who had never taken a 40 hours of training. And I think that the number 25 was, if you will, an outcome of that discussion. I would also say, and this maybe to address Mr. Dinkins' question, that those mediators who initially get certified based on the 25 mediations also need to complete the annual continuing training, I believe, under as it's discussed, envisioned at this time. Thank you.
All right. Ms. Ellis?
Thank you. And thank you, subgroup, for your hard work on this. I wanted to ask, for your training requirements, would you envision that, for example, an LLM program with a concentration in alternative dispute resolution would cover the 40-hour? I also have heard and seen in public comment situations where someone most definitely took a 40-hour training but lost the certificate because it was so long ago, and was wondering if I could get clarification on those alternative paths.
Mr. Weiner?
Thank you. So I did take an LLM program. I completed the Pepperdine program. And I can assure you that there's more than 40 hours of mediation training required to graduate that program. So I don't think there would be any question about that. if somebody did complete a program like that, they could certainly go back and get their transcripts. It may be more difficult if someone took a training, in another state or someplace where there was no records that they had completed it. That could be a challenge. But again, we haven't gotten to the administration. And one of the things that's been discussed is it might just require somebody to certify that they have, sign under oath that they have received that amount of training and where they received it and when. They may not need an actual certificate, but that's one of those administrative processes that's down the road for discussion.
All right, thank you. Are there any other questions? Any other discussion points?
Yes, just one more. And
Okay.
I don't want to get into the weeds here, but would training providers get the hourly boost the way we do with MCLE if we make a presentation that's certified?
Not yet discussed or determined.
Okay, thank you.
Okay, it's a good question. All right, thank you very much, Ms. Curtis, for your leadership, and thanks to the members of your subgroup for their thoughtful consideration and for coming up with recommendations. We really do appreciate it. Thank you. So now we'll move on to item 2.3. That's the report and discussion of baseline certification for arbitrators subgroup. And this is also on for discussion. We have read and considered the executive summary that staff has provided regarding your meetings. So we'll turn now to Judge Lucky.
Thank you, Judge Frishon, and thank you to staff for all their assistance, and thank you to my wonderful subgroup for robust discussions that we've had. As you can see from the executive summary, the subgroup consensus is different than what staff recommends. And I think what I want to do, instead of going over the differences, although I'll talk about them in broad strokes, since everybody's read them, I don't want to belabor that. I want to talk a little bit more about the philosophies that went into the subgroup's recommendation, and then what I understand to be the motivations of staff. And I'll obviously let staff speak for themselves. But we did have a lot of discussion about what did baseline mean. And I think that what it came down to was three factors that the subgroup considered. And number one was, what did the statutory language say? And we had a lot of discussion about whether the base tier was allowed to bespeak or indicate some kind of quality of service. And the consensus of our subgroup was that it did not. And so that informed a lot of how we looked at what does baseline mean, as opposed to what would come later. And then also, although we weren't considering what the qualifications for tiers would be, then what would those tiers be? And what type of additional requirements would we put onto certification if they didn't bespeak quality? And I think where staff and the subgroup respectfully disagreed was whether tier 1 or tier 0, whatever we want to call it as a baseline, can bespeak a certain type of quality, as opposed to a commitment to follow the ethical standards. And so we, as a subgroup, what we were looking at was, number one, were we putting a seal of approval or quality on arbitrators? Number two, to the extent that we were going to put on requirements, what would that mean for all arbitrators, but small shops in particular? And number three, when we put those requirements out, what would the availability of training be? And so I'll take those backwards a little bit, because I think one of the things that came up during our most recent meeting was, if we have training requirements, surprisingly, the resources available to individual practitioners or small practitioners, as far as the volume of training and availability, was much less for arbitrators than it appears to be for mediators. And so, for instance, it's I don't want to say easy, but one can find a mediation 40-hour course fairly easily. Finding an arbitration 40-hour course is a lot more difficult. And why that is, who knows? Maybe it's just there isn't enough of a market for private providers to put those out. So when we look at, all right, then what kind of barrier to entry does that have as we kind of work backward? For the small shop or for the person who is a neophyte trying to break in, when you have this issue of the training isn't necessarily available, then what kind of barrier to entry are we putting in front of that person? Or maybe it's available but difficult to find. And at least in terms of the volume of hours, although there are some providers out there who provide a large amount of training. For instance, the larger providers like JAMS and ADR Services and Judicate West, I believe, I know from my personal experience, and I know anecdotally from hearing from people, have robust training programs that are available to their neutrals. They don't make those available to the small shop somewhere else. And then lastly, if we put, and again, I'm working backwards, but if the tier 0 or tier 1 had certain types of training or other requirements above what was indicated by the statute, were we doing violence to the statutory language? One of the things that we discussed was maybe we should ask the legislature for some clarity on what the language meant in terms of the tiers not being an indication of quality. Because of time constraints and some information that staff gave us as to how that would go, and then again, really any information that we got would be advisory only, because it would be only the courts who would tell us what ultimately the statute meant. We decided to go forward with the recommendation as we put forth. And really what we were looking to do was, how can we make sure that on a recurring basis, people were committing to the standards? Because we realized that just having the standard there, everybody is supposed to follow the ethical rules. So just that by itself was not what we felt was the appropriate way to go forward. But what we envisioned was something like MCLE requirements, where periodically, every year or two, you would report to the state bar under penalty of perjury that you had kept on top of the ethical requirements, that you had read and were familiar with them, and that you were going to follow the ethical requirements and the rules of court. We also talked about having specific ethical training. And again, because of availability, we thought, well, as far as we know, there isn't a lot of ethical training for arbitrators available, although there is some. And so how many hours can we put onto that? Because again, we were sensitive to barriers to entry. And so we came up with 2 hours that was specifically devoted to the ethics of arbitration, seemed to be appropriate in terms of it was about half of the ethical requirements that the state bar imposes upon lawyers in general, and then also to deal with the availability of those types of training. Towards the end of the process, staff gave us some recommendations that were more rigorous than what the subgroup came up with. I think the concerns for the members of the subgroup who did not sign on to the staff recommendation fell into those 3 categories that I've described. So I hope I've done a decent job of summarizing where the differences in recommendations came. I'll turn it over to any members of my subgroup first who'd like to expand on anything that I've said. And I'll leave it to the chair to call on individuals.
Okay, thank you, Judge Lucky. So I'll ask staff. Mr. Weiner or Ms. Doherty, would you like to comment on the recommendations of the subgroup?
Sure, if I may, I'd also note that Mr. Palevsky's hand is up and maybe he could follow. He did join in the staff recommendation. First, one point of clarification, if I may, and I would say that we did respectfully disagree, and we had some robust discussions about the staff viewpoints and the majority of the subgroups. First thing I want to just clarify, there's a lot of quality requirement language that's thrown out that members of the working group feel that quality requirements are prohibited by the statute. Actually, the statutory language is quality assessments. So I think there's a difference between saying you have to take a training program from assessing quality, for assessing performance, kind of as Ms. Hutchinson discussed earlier today. We're all concerned about barriers to entry and properly so. However, I think that needs to be balanced against the purposes of the statute, which are, public protection and accountability. So imagine, for example, the state bar certifying a humanities or social science graduate, not putting them down as I am one, based only on their attestation that they will review the ethical standards annually and that they'll follow them and that they have a complaint procedure. I was involved in developing those ethical standards, and I can tell you that even for me with a law degree and LLM and dispute resolution, they are hard to follow. Those who work for large provider organizations are fortunate to have staff who can keep track of all the disclosure requirements. And that doesn't even touch on the extensive legal background that is necessary in order to properly carry out the functions of an arbitrator, from nomination, if you will, with the disclosure requirements, through the award. So if you have somebody who doesn't have a legal background and doesn't have any training in doing an arbitration, and they don't have any experience in doing an arbitration, frankly, it strikes me as a bit of a recipe for disaster for the State Bar Certification Program, because those folks, there's just an abundant number of areas where mistakes can be made. And in some instances, those mistakes can be quite consequential if you're talking about a binding arbitration with a significant amount at risk. And so I think, for these reasons, staff feels pretty strongly that there needs to be a training and an experience requirement. To Judge Lucky's point, the subgroup did discuss the availability of training, and it is counterintuitive that there's so much training available for mediators and expectations of mediators who are facilitating a process, and so little in terms of expectations and availability for arbitrators who are decision makers. But I did some research online. There are a number of options to get more than ample or more than the staff recommended amount of arbitration training. Certainly anybody who has gone to law school, law schools have many arbitration courses and advanced arbitration courses. There are also dispute resolution programs like at Dominguez Hills, ADR kind of certification programs that also at Pepperdine that offer classes in arbitration. I found that there are some extension programs from the state college system that offer ADR programs and offer arbitration programs. So while arbitration training is not as widely available as mediation training is, it is available, and somebody who wants to, not talking about becoming an arbitrator, anybody can become an arbitrator, but somebody who wants to become a state bar certified arbitrator, and I think staff's view, ought to be willing to make the investment of time to get a basic training in how to conduct an arbitration. So I think I would leave it at that for now, at least.
Thank you, Mr. And I do see Mr. Polewski's hand up.
Yeah, I agreed with the concepts of the staff. And let me tell you my thinking about this. It's interesting to think about what does baseline mean. I was thinking more of what does certification mean. Because certification is, as Ellen said, we're putting the state bar's name and saying this is good or good enough. And I think that to be certified, you need to do more than say you will follow the ethical standards, because the ethical standards are already mandatory. Under the California Arbitration Act, they are non-negotiable and non-waivable. So simply saying you're going to follow mandatory, non-negotiable, non-waivable standards doesn't say anything to me. So I thought that certification should mean something more than that. Arbitration, as opposed to me, and I don't mean to, I love mediation, but arbitration as a binding process is a more legal process with much bigger stakes and is very complicated. The ethics rules are very complicated. The process and how to conduct an arbitration is very complicated. And I just think that I don't have an opinion as to the right number of hours, but I know that AAA and JAMS have very extensive training programs. When we were in our subcommittee group and they were explaining how many days or a week long that the people who try to train take, I really do think that you really need to have an understanding of the process, of the law, of the California Arbitration Act, of how to conduct discovery in the different contexts. And I think the ethics rules are critical. I don't think they're sufficient so far, but I really do think they're critical. But all of that to me is dependent on the state bar creating some training. And it can be done video training, online training, something that is accessible time-wise, convenience-wise, because I don't think there's enough out there right now. And I think that my agreement with the training and ethics requirement really depends on the state bar stepping up and making sure that there's something adequate and accessible out there. Just a thought that is not, I don't know where we're going to capture it now or later, but I really think we need rules against AI written awards. Not the use of AI in research, but I don't think awards, and whether that's an ethical rule or an additional ethical rule, I don't think awards should be written by computers.
Thank you, Mr. Polewski. Dr. Getz?
Oh, excuse me, let me lower my hand. So thank you. I also agree in concept with the staff recommendations, as opposed to no training whatsoever. I do believe Mr. Polewski's got it right that the public's going to expect that there be some credentials that go with being an arbitrator that's certified by the state bar. As president of MC3, I had a lot of chance to research how states interact with occupations, and there's really 3 levels of interactions. You can register in some states to be an occupation, a practitioner. Other states require certification, which usually is an exam, and of course no exams. And then the final, most rigorous stage is licensing, where you bar non-practitioners from even practicing. So the statute is saying certification that we're trying to work with. And so I think we are required, maybe not to have an exam, but to have some set of qualifications. But I also profess not to know the magic that goes into the staff recommendations on hours and whatever, but I would have a friendly consideration to make to the staff, friendly recommendation if we are to process those any further, and that is, would you consider judicial or bench officer training in lieu and experience in lieu of arbitration experience? I know I spent 6 years as a judge pro tem for Los Angeles Superior Court, and I would think that the training I received for that, as well as the 3,000 matters I handled during that time, suited me well for my role as an arbitrator. And I'm sure that's true of commissioners and judges as well. So I would just ask staff if we process those recommendations further to consider judicial or bench officer training as well.
Thank you. Oh, yes, Ms. Jones.
Thank you. Speaking to the concern about there's not very much arbitrator training, I would encourage the subgroup not to be too concerned about that, insofar as if you build it, they will come. There also, was a recent CLE requirement introduced pertaining to technology in the law and civility, and another one, wellness competence. And, there were not previously programs speaking to those requirement areas, and now you see them emerging all over the place. So if we have a requirement pertaining to arbitrator training, I suspect many, many organizations will jump at the opportunity to create that training and offer it at a charge.
Thank you. Good point. Anyone else? Okay, well, I don't see any other hands. Please let me know if there are some more up. Otherwise, thank you so much, Judge Lucky, for your, oh yes, Mr. Weiner, I see you.
Oh, Judge, I was just pointing out that Judge Lucky had just raised
Oh,
his
okay,
hand.
Judge Lucky, yes.
Just briefly, because I saw Ms. Cruz had raised her hand and hadn't had an opportunity to speak, and I just wanted to, but now it seems like her hand is down. I just wanted to make sure that if she wanted to speak, that we gave her a chance.
Oh, yes. Ms. Cruz?
I don't see
Ms. Cruz may have
all. She
mentioned
had to
earlier that
pop
she
off.
needed to.
Yeah.
Oh, okay, okay. All right, so Judge Lucky, I wanted to tell you thank you so much for your leadership, and to thank your thoughtful subgroup members for their consideration and the time. I know that you guys met quite a few times. And thank you for all of the time and consideration that you've given to this. Thank you. All right, so we'll move on now to the last one was just on for discussion also. So we'll move to item 2.4, and that's possible action on recommendation for baseline certification for mediators and arbitrators. I'm going to ask Mr. Weiner if he'll start this off for us.
Well, thank you, Judge Bashan. I think you've really, you've heard a lot in terms of representatives, leaders and members and representatives of subgroups and staff. I think, that the presentations have all been pretty thorough and well thought out, and you have some different views that have been expressed, some questions that have been raised by members of the working group who aren't on particular subgroups in question. So I'm not going to take your valuable and diminishing time to reiterate what's been said. If I may, possibly later in the discussion, if there's time, perhaps answer some of the questions that were raised, but thank you.
Okay, thank you. And Ms. Doherty, is there anything that you want to say before I jump in here?
No, I'll just point out the two attachments. So we did receive a lot of questions about statutory interpretation. We heard that at the working group meeting back in March. We heard that in the subgroup discussions in both the mediator group and the arbitrator group. And so we asked for very quick advice from our Office of General Counsel, which they graciously let us publicly post. And so you have seen that brief memo really answering two very small questions. I think there will be many more questions that we may need to get some guidance on, but because of the time constraints, we wanted to have that for this group for purposes of discussion. The other thing that you have seen, but that was posted, very right before this meeting, is a kind of holistic view of all of the recommendations. I can certainly screen share that. I will just say personally, I don't I think what would be helpful is to get a sense from this group as to the direction to take in light of the OGC advice. And so forth. I'm not sure, given that there's 8 minutes left in this meeting, that it makes sense to get into the nitty gritty, if depending upon the will of the group. But Judge Pichon, I will leave that to you to decide.
The discussion has been robust this afternoon. There's been some really great comments and recommendations, and I can see how much thought everyone has put into this that I would like to move forward, and if you don't, that's fine. I just would like to find out. And so our goal at this time is to vote on whether to recommend to the board minimum certification requirements beyond those listed in the statute. And I want to know if the group would like to and is prepared to vote on that. And Ms. Doherty, is that something you can screen share?
Yes, I prepared a very draft resolution, so I would welcome one. We would of course need a motion, and then anyone who wants to,
All right.
propose revisions.
All
Give
right.
me 1 moment to share.
Okay, thank you.
And so this would be limiting it to the limitations in the statute, and then as an alternative, this is kind of, again, in concept, something beyond what's in the statute, and we would basically be adding bullets. So there's really two options. I don't know how small I can make it where you can see them both. Let's see. At the same time.
Erica, just a moment ago, you had them showing side by side, which might be a
That
good
was
way to
actually
look at
something different. Can everyone, I think this covers most of it. Can everyone see these mostly? Maybe if I put them closer to each other. There you go. So the top half is the confines of the statute. The bottom half would be something beyond that. We've discussed largely training and some sort of experience. It says in concept for a reason. I know that the mediation subgroup has not gotten to what that experiential requirement might look like. And I know that the arbitration subgroup would like to my mind, stay mostly within the confines of the statute. They proposed an alternative recommendation that all of you have likely seen in their memo to have a 2-hour training prior to certification on the ethical standards, and then on an ongoing basis as part of recertification.
All right. I'll give everybody the opportunity to review it. And if you're ready, or if anyone's ready, I'll accept a motion. And we have 2 resolutions on the screen.
Daniel Yamshawn moves for a vote on alternative 1.
And Mr. Damson, I'm just going to add alternative 1 to the beginning, just so that people know.
Okay.
I hope they do, but I'm going to put alternative 2 to the next one.
Right.
Great.
Thank you.
All right, I have a motion. Is there a second?
I second.
And who was that?
Jenna Ellis. Thank you.
Okay, thank you. All right, well, we have a motion, and yes, Mr. Kelly.
Thank you. Just personally, I have no problem with the 2 that have been added, training and experience requirements, but I was very troubled last time, and still am, that we have such a split between the subgroup for mediator qualifications and the one for arbitrator qualifications. And it doesn't make sense to me to have a whole bunch more requirements for mediators than arbitrators. I'm still troubled by that, and I don't know what to do to resolve that. Thank you.
Okay, let's see, Mr. Tuckman?
Thank you. Yeah, I had the same question that Ron just noted as well, noting these distinctions. Just as a matter of process on the current motion, how is this going to work? Is there going to be a vote on alternative 1 and then separately on alternative 2? Is there a winner in just among these two? How is that going to work?
Judge Pichon, I can address this if you'd like.
Yes, Ms. Doherty, thank you.
Okay, so if alternative 1 were to pass by the working group, so if there was a majority of yes votes, that would theoretically end the conversation on expanding it to option 2 or alternative 2. If alternative 1 failed with a majority of no votes, then there could be a second motion, a new motion for alternative 2. These both say in concept, what I would think is that and this is just because I drafted them very quickly, I would think with alternative 1, it would likely, and I would ask Mr. Yamshawn and Ms. Ellis if there's a friendly amendment to remove the in concept from alternative 1. I think for alternative 2, you would keep in concept because I think there would be a lot of work to get alignment in some, or not even necessarily alignment, but that's a thing to discuss, but to determine what the training and experience and pathways and all of those types of devil in the details type things should be for mediators and for arbitrators.
Okay, and Ms. Doherty, thank you for that. Would you also clarify that alternative 1 and alternative 2 both apply to mediators and arbitrators?
Yes.
Okay. Yeah.
This is Daniel. I'm not convinced that it needs to apply to both. But all right. The reason I'm not convinced is because it seems to me there are a lot more people attempting to get into mediation and a lot more people who have gone into mediation than have gone into arbitration. And there's various reasons for that. And one of which is because of the explosion of mediation training. The community mediation centers have been a fertile ground to create new mediators. And sure, there's plenty of arbitrators in the state of California, but I don't think there's nearly as much impetus for people to go into arbitration as there are in mediation, particularly because kind of the culture of mediation, it's a very cool thing to do. And arbitration isn't really seen in the same light.
Okay, thank you very much. Mr. Pileski?
Yeah, two things. Am I right that if the group votes for alternative 1, it undoes all of the work done by the mediation subgroup? All of that work seems to be out the window if number 1 passes. And 2, as it relates to the arbitration subgroup recommendation, there was a reference to ethics training of 2 hours, but the way I read the document, that was only if this larger group approves it, that the actual recommendation of the arbitrator subgroup did not include even ethics training in the actual proposal. So I just have a hard time undoing everything that's been done, but people can vote how they're going to vote.
Can I jump in? I realize I'm being very impolite. I think that the arbitration group saw this as arbitration. We didn't mean to impose on the mediation group or the mediation group's hard work. So perhaps this could be clarified that our alternative 2 could apply to mediation and alternative 1 can apply to arbitration. And Jenna, I realize you're the second, and I would ask whether or not you would approve of those amendments.
I think, Dan, given the time and the number of hands, perhaps we need more discussion. So I'm almost inclined to withdraw my second for now.
Okay.
I was just reading in the chat, but I see Mr. Wiener's hand up. Can you, would you go ahead and then I'll call on the other people?
Sure. Just making some observations here. One is that there seems to be some interest in having separate votes, one for arbitrators and the other for mediators. And the second observation is that if I'm not mistaken, alternative 1 and alternative 2 are essentially the same other than the last 2 bullets. So I think to avoid needing to vote on 2, if that's going to happen today or in the future, one question could be framed either separately or jointly for arbitration and mediators is, should the working group recommend training and experience in addition to the requirements set forth in the statute? And then that could be, again, separately for mediators and arbitrators. The other thing I'm noticing, I think in Erica's haste to put together these resolutions, there should be a 4th bullet for alternative 1, at least for arbitrators, because I think that even the subgroup majority recommendation was that there be an attestation to having read the standards of conduct, which I'm not seeing quickly here.
Okay, so I see more hands up, but I've also read in the chat where a couple of people have to come off and have asked that we continue this discussion to another time. So if it's really pressing that you would like to speak, keep your hand up. And I'll just ask you to briefly state what it is, because other people have other meetings they have to go to. So I saw Mr. DeBoe's hand and Dr. Getz's hand up. Mr. DeBoe?
Well, we haven't voted on the arbitration or mediation committee's proposals.
Right.
And we got, in my case at least, I only got them a couple of days ago. I haven't really thought them through. And now you're asking us to vote on something else. I propose that we postpone all these votes until the next meeting.
Okay, Mr. DeBoe, just to clarify, the other items were on for discussion. I did not call for a vote for them.
Then I think we should postpone this one.
Okay, I understand. Dr. Getz?
Judge Bashan, in the interest of time, I think we ought to move on, and I can withhold my comments till later.
Okay,
Thank you.
thank you. All right, so I'm now going to defer to staff regarding what we can put over to the next meeting.
Yeah, I'll speak to this. I think it's just fine to put this over. What I think staff can do and work with the chairs to accomplish is to determine how to package this in a way that now that we've had these subgroup discussions that would facilitate additional dialogue as necessary, and then votes on these types of actions. What I think what we'll need to do, again, because it's 5:05, is determine what, if any, action the subgroups might continue to take in the interim between today and our next meeting, which I think is on May 29th. So this is, I think, one of our larger gaps between meetings. So we will communicate, staff will communicate with the subgroups and the working group as to how things will kind of move forward in the interim between this meeting and the next, if that's appropriate.
That sounds like a good plan. So everyone, this was a really wonderful discussion, and everybody was totally engaged and involved, made some wonderful recommendations and suggestions, and I'm truly grateful for the courtesies you've given to me and to each other. Thank you very much. So because we've passed our time, I'm sorry, but it was a really good meeting, and thank you so much. So we will adjourn.
Thank you.
Thank you all.
Bye, everyone.
Thank you again for your excellent facilitation, Judge Bichon.
Thank you so much.